Hello, everybody. Hey, Madeline. How you doing? Nice to
Hello,
see you.
everyone.
Happy spring. Happy spring, everyone. Hi, Joe. Brenda, nice to see you. It's good to see everybody coming in. A lot of people with their cameras off. Beautiful day today, so I'm going to try and get through it quickly before. Hey, Beth. Before we see the rain in. I think we're supposed to have rain rolling in tonight and raining on us on Saturday. So I'll try to get through this and so you get out there in the sunshine. So couple administrative things first. Thank all of you for being here. Just so you know, we move to summer hours in June next month. So summer hours in June, which means we start at noon instead of 4 o'clock. Because I know all of you managers like to do your walkthroughs on Friday afternoon in the summertime. So I don't want to impede your property inspections. All right. So keep in mind in June, first Friday in June, first Friday of the Friday in June, it will be starting at noon. So let's go with dog of the day real quickly. Today we have Wyatt, and I think many of you have seen Wyatt before. Wyatt is a poser, as you can tell. Wyatt is like a model dog, and Wyatt is owned by Robert Thomas, who is from Cedar Crest Management. Robert's been in the industry a long time, and he is more recently with Cedar Crest Management. So thank you, Robert, for sending in the picture of your dog Wyatt, and good luck in the new position there. And also, I wanted to mention as kind of a footnote, we are a little light on dogs of the day. So if you have a dog of the day picture that's not a repeat from this year, please don't hesitate to send a picture of your dog in. So there's that. And then we have my usual announcements that annoy everybody. This seminars are for general informational discussion purposes only. They do not and cannot form an attorney-client relationship. Let's see. Number 3, information exchange does not constitute legal advice. That's really important today because we're talking about a very complicated and nuanced and fact-sensitive area of the law, which is employment issues. You have to obtain legal advice, you have to go out and contact an attorney directly, explain your own facts to him or her, particular situation, sign a fee agreement, and then set up a relationship and move forward there based on real facts. No information will be kept confidential. So again, we're in the employment context today. So I would suggest you don't get into, if you have a particular issue on your site, hey, Fran, hypothetically, I have this guy, Kenny, who is doing this to Mary Jane. Is that a problem? And the reason for that is I don't want my tape of this recording of this session subpoenaed. And I certainly don't want to spend an afternoon in a deposition talking about what was said on one of our first Fridays with Fran. So there's that. Then I have one more addition, and probably most of you know this. I'm just going to share the screen for 1 second. So most of you probably know this already. So Wendell Smith passed on April 13th. Many of you probably know Wendell Smith. He is a legend in the industry, in the community association industry in New Jersey. He basically, in many respects, was a founder of the community association industry in New Jersey. He's with the Greenbaum firm. Very nice guy. I admired him. And he came out of, prior to joining the Greenbaum firm, he came out of the Levitt organization. For those of you who know Levittown in Pennsylvania, Levittown in New York, and Levittown in, it's now known as Willingboro, but Levittown in New Jersey is now known as Willingboro, but that was a Levittown as well. So kind of the post-war kind of planned unit developments before they were planned unit developments. So thank you in honoring Wendell. And he had a great life. He lived to 93, so that's a great life. And I think he was healthy for virtually all of it. So God bless you, Wendell, and Godspeed. So that's that. And let's see. So we'll go on to the kind of the meat of what we're talking about today. Independent contractor versus employee in the employment context. And I've had associations who've had what they called independent contractors, which would be a maintenance man. And it just so happened that the state of New Jersey investigated them, and they made a determination that the person was not, in fact, an independent contractor or maintenance man, that he was actually an employee of the association. And the reason for that was that the association was unable to show that he was an independent contractor. So what is the test? What is the test for independent contractor? It's basically called the ABC test. Um, the um, the employer must show. So the ABC test presumes the person is an employee, unless the employer can show the person has been and will continue to be free from control, both under the agreement and in actual fact. You see what I'm saying? So if there's a contract that just says, hey, you're an independent contractor, this is the work you'll be doing, blah, blah, blah. And by the way, you're going to be an independent contractor, but every day someone from the association is supervising that person, telling them what to do. It really doesn't matter what the agreement says if in reality um, the association is controlling and directing the person's work. The service is performed outside the usual course of the business. Um, for which the service is typically performed, or that such service is performed outside of all the places of business of the enterprise. So this is where someone be performing things or making things off-site that really don't have to do with the association. It's not part of the typical association business. Um, it's totally separate. That's the second factor, the B factor. And the person is customarily engaged in an independently established trade, occupation, profession, or business. The failure to satisfy any one of these conditions means that person's an employee for the purposes of um, uh, certain law in New Jersey, right? So and there are different tests in different contexts, but basically we're talking about New Jersey's wage payment laws and wage and hour laws. So what happens, right? So the state has a tremendous policy interest in, number one, making sure people get paid fair wages, minimum wages, things like that, that make sure they're not worked to death, right? So if the person is an employee, they're subject to overtime laws, limits on how many hours the person can work, all those fun things. If they're employer, what else does the state do? The state collects taxes, right? If you're an employee, right? If you're an employee, the employer is required to collect taxes, and they have to be taken from the employee and turned over to the state. So many people like to say, no, 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 this guy or this lady is an independent contractor. We don't have to give them benefits. We don't have to give them any protections under the various laws. We're just paying them what we've agreed to, and we have nothing to do with it. We have no obligation to pay to the state. What happens if the state comes in and finds that there's a person who the employer or the association in this context is improperly categorizing as an independent contractor? The state can come in and, number one, um, glom any money that the association would have owed if they treated him as an employer. They can penalize the association, and they can make sure that the employee, if the employee was not being properly paid or properly given benefits, gets those benefits. Okay, so you don't want to wind up doing that. So be very careful. One kind of way to think about it is, and this applied to the association example I was giving, um, if that person was not doing the work for this association today, would they be unemployed? Right. And the answer in my example was yes, because the guy was basically working full time for the association. He had no other work, even though he claimed he had tools and a van and he was doing other stuff. In fact, he was not doing work at any other associations. He was really just working full time for the association I'm talking about. So if they had said, Bob, we're done here, it's not like he would have gone to another job site. He would have been unemployed. So that association couldn't prove really any of those factors. What about pass-through employees? What are they? So pass-through employees are generally when a management agreement is set up that their typical management agreements are set up one of two ways. Number one, the management company says, you will pay us $250,000 a year. And as part of that $250,000, we are going to do all back office. We're going to do bookkeeping. We're going to do violations. We're going to do status reports, all that fun thing, management reports. And we're also going to provide you with an on-site manager and an on-site administrator, right? It doesn't talk about what the on-site administrator is paid as a salary. It doesn't talk about what the on-site manager is paid. That's on the management company to provide somebody to the association within the $250,000 fee, um, such that they satisfy the association, right? The pass-through type entities, or contracts, I should say, agreements, are where the management company says, we are going to charge you a management fee, say much less, $100,000 instead of 250. However, you still need a manager and you still need an assistant. And what we're going to do here is you can pick whoever you want and we'll make them our employees. But if you want to pay that person $250,000, that's great. If you want to pay them 100,000, that's great. You can control. We'll show you some people, but you control the quality. You control the selection. Oftentimes, you control what they're being paid. We're going to just pass through the cost to the association. Plus, we're going to add our fees, our surcharge, or what have you on top of that. Right? Does that make sense? The the risky thing, and we'll talk about this in a second, the risky thing there is some associations, when they see that, the board members will say, they're not our employees. They're not our employees. They're the management company employees, which is true in fact. But when we get to the next topic as a possible joint employer, oftentimes those situations run into the association and the management company being a joint employer. And there's a joint employer test as well, right? And just so you know, the joint employer test is some ways similar to the independent contractor versus employee test. But in the joint employer context, the situations can be significantly broader because even with the independent contractor test, they can apply in different contexts. And what I mean by that is there can be a test under New Jersey law against discrimination, for example. There can be a separate test under the Family Leave Act. There can be a separate test under the let's see, the wage and payment law or the wage and hour law. So there can be separate tests under federal law versus state law. So some of the main characteristics that we talk about when there is a joint employer risk are, number one, the employer's right to control the means and the manner of the worker's performance. Control is a huge factor whenever courts look at who the true employer is and if it's a joint employer. So many, as you know, especially in the active adult communities, many times an employee of the management company is put on site at the association, but the board members may be very, very, very involved in handling their day-to-day assignments, supervising them, giving them reviews, things that a typical employer would do. So generally, if the level of control is high, it's much more likely that a court will find that it's a joint employer. The kind of occupation, supervised or unsupervised. So if it's supervised, it's more likely that the association will be found a joint employer. If it's unsupervised, it's more likely that it would be by the employer itself, in this case, a management company. The skill used, if it's a high skilled position, it might be more likely to be the employee of the management company. Who furnishes the equipment and the workplace itself. So if the association, in our case, is furnishing the equipment, which generally they do, and the workplace, think about the large clubhouses with large management offices, office equipment, fax machines, copy machines, computers that the association focused. They're all factors that will weigh in favor of the association being a joint employer. The length of time in which the individual has worked. So if the individual has worked for the management company on your site for 6 months, and then she's working somewhere else for 6 months and somewhere else for 6 months, that's going to be a factor weighing in favor of the management company being the employer. But if the manager has been on your site for the past 15 years, that weighs in favor of being an joint employee of the association, and the management company. The method of payment, who actually pays the employee in this example as of a pass-through, the employee would be paid by the management company, but it's hard to say who determines the pay scale. So we've had much debate with some associations where they said, Fran, we would like to have the pass-through arrangement because we want a higher level manager, so we want to pay more. We don't want the all-inclusive management agreement where management just plugs somebody in here and we don't know what we're getting. Because if we're paying $250,000, we want to make sure we're getting a high-level manager and not having a manager that the management company is plugging in that we may not be satisfied with. The manner of termination of the work relationship. So who controls termination of the work relationship? So in a lot of associations, especially active adult communities, um, but even non-active adult communities, the board has a lot to say with respect to whether or not the manager stays or goes. So oftentimes the board member's opinion weigh heavily in whether or not the manager is hired, fired, retained, etc. So to the extent that the association has a lot of control in terminating a manager or an employee, that weighs in favor of a joint employee relationship. Whether there's an annual leave, whether the work is an integral part of the business of the employer, whether the worker accrues retirement benefits, whether the employer pays Social Security taxes, and the intention of the parties. So many of those things are very similar to tests under the independent contractor versus employee standard. And that's just one test. As I said, in the joint employee context, joint employer context, you have to remember that it it varies depending on what the claims are being made by the employee. One thing to keep in mind is what is the worst thing that you can do in an employer relationship is nothing, nothing, right? You don't want to do nothing if there's an issue. If the association learns of an issue, the association and the management company are obligated to investigate. So that's why I have point 4 here, management company and or association to act, right? Management company or association to act. This is a real point of struggle and contention in our world right now, because many times the association's board is so intimately involved with the workings of the management office that the management company sometimes feels like, hey, Fran, if there's a problem, you got to deal with it, Fran. And I'm like, well, wait a second. Isn't this person an employee of the management company? If there's a claim, you should be investigating what's going on with your management staff. If your manager claims that she or he is being harassed or abused or treated improperly, the management company should be investigating it, and the association, in my opinion, should be investigating it as well, unless the management company is being very proactive and is giving you reports on what they're doing proactively. I think that can work well too. I have cases which go both ways where management company in-house counsel works hand in hand with me to investigate things, follow up on things, follow up on claims, and we investigate them and address them as necessary. I have others where the management company is like, deal with it, friend. I'm like, wait a second. Should the association have to pay a lawyer every time there's an employment claim? I'm not so sure of that. So it's a balancing act. And for those of you who are on the management side of things, especially if anyone's on today from the executive offices of the management company, it's something that is going to continue to grow in importance because both the management company and the association have significant exposure in this area. Keep in mind also, and this is a footnote, I don't really mean to get into this today, if a board member does something intentionally wrong, it is unlikely that that board member will be covered by insurance. And what does that mean? If the association's board member sexually harasses somebody, for example, that's outside the scope, obviously, of their role as an association board member, and the carrier would very likely deny coverage in that case. So you got to be very, very, very careful. Employment issues are big issues for associations and management companies these days. Workers' compensation insurance. This is a really confusing area in associations because a lot of association boards go, Fran, we have no employees. Why in the world will we have workers' comp insurance? And generally, the response of the insurance representatives is that it provides an additional level of security, number one. Number two, it's vis-a-vis its cost. It provides some coverage. Number three, it's often included in many package programs that are sold in the association industry. And number four, it actually may provide coverage when coverage is not there, even though when vendors are supposed to come on your property, they're also supposed to provide you with proof of insurance, proof of a policy, etc. Proof of insurance generally does not do anything for you because it's helpful. I mean, get it, have managers get it. We want proof of insurance, but that doesn't mean that the insurance itself will be continuing in effect, right? Somebody could give you a proof of insurance today, and even though they're not supposed to cancel or non-pay without providing the association notice, they can still do that. And the association may still have some exposure there. And if you have comp insurance, that may help have your claim covered. The other odd thing about joint employer status and workers' comp, when you're talking about those two concepts, is for those of you who know or somewhat familiar with workers' comp, and I'm not a workers' comp attorney, if an employee is injured on the job, they are covered by the Workers' Compensation Act, right? Which means that they can't sue the employer outside of the workers' compensation claims that they can pursue. The interesting thing about the joint employer concept is, well, what type of rights does an association have to claim as a defense if someone's injured on the job, that employee claims against the management company, and the management company says, that's fine, you have a claim, we're going to pay under a workers' comp policy, and then that same person attempts to sue the association as an independent third party that should have prevented the harm. There's an argument, if there is a joint employer relationship, that the association should also get the benefit of the bar to a third party claim as the joint employer. I know that sounds kind of odd, but it also makes some sense because if both the association and the management company are the employer, in theory, the person should be paid in full under the workers' comp insurance policy and or workers' compensation policies of both the association and the management company. Not a double payment, but perhaps a shared payment. So that concept of joint employer can work in favor of the plaintiffs at times, but it also can work as a defense on workers' comp claims on behalf of the employers. Okay. Employment practices liability insurance. We've talked about that before. Everyone should have it. Employment practices liability insurance will cover and, more importantly, defend many of these claims. Very helpful because many of these claims are about what? Attorney fees, right? There may be no basis to the claims themselves. There may be little or no recovery under the claims. There may be a nominal settlement of the claims, but you may spend hundreds of thousands of dollars defending the claims, going to depositions, sitting in depositions, giving testimony, going through boxes and boxes and boxes of documents with lawyers, only to find that there's no claims, but you spent tons and tons of money on, one second, on lawyers, right? Again, you hear me say this all the time. That doesn't offend me very much, but as lawyers for association, I want to see you control your attorney fee spend. And I would rather see you, there's enough legal work, thank God, in the community association field, thank God. I would rather see you spend your money on retaining walls or paving or pavers or plantings or flowers in the entryway, right? That's great. We love curb appeal. Try to minimize spending it on lawyers, and you can really do that if you have proper insurance. I know I'm preaching to the choir, but your insurance broker, in my opinion, again, should be live and in person in front of the board once a year. What's happening in industry? Why is our loss history what it is? What are the numbers? Where is the industry heading? Are there new insurance products out there? Is there cybercrime insurance? Should we have cybercrime insurance? What type of information do we hold on our computers at the office? What if they get hacked? What if someone steals somebody's identity because they got copies of their driver's license from the association's files? All those fun things, right? So there should be a bit of an insurance workout annually, at least, with the association's board, just to have an update, because the insurance industry is constantly changing. There are new products coming out, and as the technology world in particular evolves, which is evolving faster and faster and faster, you're seeing more claims and more products from the insurance side. Just to scare you a little bit, I'm going to share my screen again. Let's see. Bear with me one second. So this is a nice blank screen, right?
There we
See
go.
the nice blank screen?
Yep.
Okay. So I'm just going to type, this is how easy it is, right? Correspondence. Well, I'll do letter, so I won't be fancy. Letter to my employer complaining of disability discrimination. 1, 2, 3, 4, 5. Oh, it was faster. Oh, there you go. So figure about 10 seconds. I mean, I think earlier today I was getting them in like 3 and 4 seconds. But so this is like 10 seconds. Really nice letter. I hope this message finds you well. I am writing to formally raise a concern regarding what I believe to be a violation of my rights related to disability discrimination in the workplace. Really nice. As you may be aware, I have a disability or I am a person with a medical condition that affects my ability to perform certain tasks or require accommodations to ensure that I continue to work productively and effectively. This is a really conscientious employee. Okay. Unfortunately, I've experienced, and then please fill in what's happening, of discrimination or lack of accommodation, such as denial of necessary accommodation, unequal treatment, or any other form of discrimination or bias, right? So you just plug that in there. For example, and then you provide your examples. Um, these actions have made it difficult for me to perform my job and have created a challenging and unfair work environment. I believe that these actions violate my rights under the Americans with Disability Act and have affected my overall ability to perform at my full potential. I would like to request that the company take immediate action to address these issues, including blah, blah, blah. That's what the action you want, right? The accommodations desired. I am committed to continue to contribute to the company and would appreciate any necessary adjustments to allow me to do so effectively. Please let me know when we can meet to discuss this further. I would like to resolve this matter as quickly and amicably as possible. I am confident that with a collaborative approach, we can find a solution that supports my ability to perform my job well while ensuring the company adheres to legal obligations. Thank you for your attention to this matter. I look forward to your prompt response and resolution that ensures a fair and supportive workplace. Awesome. No threats. How friendly ChatGPT is, right? I'm not going to sue you tomorrow morning. But wonderful letter, right? Wonderful letter. And if I typed in, give me a correspondence complaining of sexual discrimination in the workplace, um, similar thing would come up. Racial discrimination in the workplace, similar thing. Um, you name it, right? And I have seen, just so you know, I've seen a number of letters. I don't really know if they're Chat GPT, but they sound a lot like that, right? They sound a lot like that. Very nicely written, very conscientious, very middle of the road, non-threatening, but checking all the boxes in that I put my employer on notice of how I desire an accommodation. These bad things have happened to me. Please take action immediately, right? Okay. So this is out there, and it is a challenge from both I'll call it the aggrieved side of things, right? So the aggrieved side of things, we'll call that the victim, and the perpetrator, if you want to call that, right? So it is very, very easy in today's world to be aggrieved, right? So you have to be cautious because, right, for the manager, any managers on the phone? Yeah, we see the managers there, right? How many of you have experienced people not being nice to you in the past week, right? It's unanimous. Nobody showed hands, but it's pretty much unanimous, I see. And the problem with that is that discrimination? Is that harassment? Is that a hostile work environment? We don't know, right? Because it's so fact sensitive. But many, many people right now are very concerned, and it's so available to be aggrieved that many associations are spending lots of money addressing concerns that maybe 2, 3, 4 years ago uh, would not have risen to the level of anything. By the same token, on the flip side of things, we've seen a lot of people more threatening, more harassing, and more physical post-COVID too, right? So we're dealing with both sides of the coin, the aggrieved person and the harasser themselves. The world has changed, and you've heard me say that many times. Um, that being said, how are we doing on time? We're doing good on time. So I showed you that. I showed you ChatGPT. I talked about the time. I have one or two questions that were actually emailed in. This is a tough question, but I'll try my best. If an employee confides in a board member or a resident regarding harassment and retaliation, does the board member or resident bear any responsibility to report it? That's a question in the employment world. This is not legal advice. Again, these are just discussions. So if you have a particular issue, I need to know the facts, or the attorney for the association needs to know the facts. But I can tell you how I've handled these types of things in my own firm. As the owner of my firm, I believe very strongly that I have a duty, I have an obligation to act. So if someone comes to me and says, Fran, ABC did this to me, don't tell anyone. I don't want you to do anything about it, but I just want you to be aware. I act. Okay, I act and I stop the conduct, right? Take steps to investigate it. I take steps to stop the conduct. And I've even had people subsequently come back to me and say, Fran, I told you I didn't want you to do anything. Well, in my mind, and this is applying to my office here, I cannot have a hostile work environment. I cannot have any type of illegal discrimination going on. So I act. The question gets a little more complicated is, what about the person who's not a board member? So in the board member context, I would generally say, and again, and not legal advice, I need to know the context, et cetera. But I would generally say that a board member in an organization has an obligation to report it to the board and take act to stop to investigate the complaint. And if they find that there are problems, to stop the problems. What about just a resident? The question on a resident is, does the resident have a duty? I'm not so sure. I don't know the answer, but I'm not so sure that a resident has a duty to act on another resident's complaint or an employee of the association's complaint. Is it a good idea, I think, to go to the employee who comes to you and says, hey, you know, Bob has been grabbing me and he needs to stop, and I'm afraid to tell anyone? Um, I think so. But I'm not so sure of the duty basis there. So I'd have to say I don't know at the moment. I would encourage whoever a resident who got that information to try to convince the person who passed that information along to go to the employer, an employer representative, or a third party of the employer, um, that they feel comfortable with the information. Otherwise, how does anyone stop? It's very difficult to stop things without knowing. So like in my firm, we have a third party HR consultant that if somebody is not uncomfortable coming to me or coming to another person in the firm, like my office manager or another attorney in the firm, they can go to that outside HR manager and say, hey, this may be a problem, this may not be a problem. I'm just really uncomfortable and I want to know if this is right or not right. It doesn't feel right. And that HR manager takes steps to investigate it. So there can be third parties in the example in the question that could be a resident. It's just that I would need to know more facts and I would need to know what the relationship is of the resident and the potential employee. Let's see, question 2. Does the board member have a resident have a employee? If all possible. If at all possible, would you find a way to speak in a general manager regarding the following: employment, harassment, and retaliation? So in general, employee harassment, retaliation, I think I just spoke a good bit about that. Employment, harassment, and retaliation shouldn't happen in the association context. Too many people think an association is not a real employer, it is not a real workplace, and that the board is not a real business group of business leaders, that the association is not a real business. And they poo-poo things like, we need to do an investigation of these circumstances. That's just not right. Number one, it's not legal, but number two, morally, it's not right. And the people are entitled to a safe workplace. And the association and the management company have certain rights and duties with respect to doing that. That being said, I don't want to make this too dry today, but I'm going to jump onto the questions too. Mike, you want to jump on the chat?
Yeah, just a couple here. So I'll read them out because they really pertain to what you talked about. So first question said, what if you are performing similar functions for other entities? I think they're talking about whether or not you are an employee or an independent contractor. So again,
Oh, okay. What if you are performing similar functions for other entities? Is
yeah.
that okay? So what if you are performing? So Janet, what that does is it weighs against being a joint employee, and it weighs in favor of you being an independent contractor, right? The thing is, you would have to also, to be an independent contractor, you would also have to fulfill those other requirements. Um, the person has been and will continue to be free from control, both under your contract and through the service in fact. So even if you are performing work for multiple associations or multiple workplaces, if you are being controlled, that may still make you an employee under the test. Um, so you have to be careful in that. So if somebody was an electrician and they're going from an association to a single family residential home, and then they're going to a business and a commercial strip and all those other things, and all they're doing is switching out the old school um, lights in the office areas to the new LED lights, probably more likely an independent contractor because nobody's telling him or her how to splice the things and how to put the wire nut on and all those good things. Um, but if it's controlled, probably not. Um, I want to mention Beth mentioned that her dog Bella passed. That's awful, Beth. I'm sorry to hear that. It is terrible. For those of you who are dog people on the call with us, that is like the worst thing that can happen, right? Your dog passes. That is the worst. So I'm sorry to hear that, Beth. Beth also mentions that she grew up in Strathmore in Matawan, which she says was a Levitt development. So Levitt did great things post World War II in terms of planned developments, planned communities, and we'll say entry level housing, right? Giving an opportunity for many of the post World War II veterans to come back into the USA and realize the American dream of home ownership. What a lot of people don't realize about the Levitt developments is even though they were sold and marketed as first homes or initial homes, they were also designed, and there's a really good book on the history of Levittown um, and the Levitt organization. They were also designed to anticipate additions, right? So you could get into a Levitt home in a certain model, and there were what we would call standardized additions that so that a family could grow in many Levitt homes by
Mm.
making addition after addition after addition. Many people don't realize that. So you could get into the American dream relatively affordably, but at the same time, it could grow with your family or as your family changed. So that's great, Beth. Maybe I should send you the book. I think I have a copy of the book somewhere. Um, where are
Yeah.
we now?
Yeah, so Nicole said, just a comment. What's up, Nicole? Love the chat GPT usage. And just side note on that, it's gotten to the point where it has a memory, right? So you could ask it a question, it'll prepare a whatever letter for you. And you could say, hey, make it more aggressive, make it XYZ. Here's the context. And it will continually revise it and make it better and better. So it's
Yeah.
crazy.
Yeah, things are going to get real interesting real fast in lawyer world.
Yeah.
We're going to see a lot of things change in the next couple of years. Uh, Mike says, hey, with a contract in force with a management company providing a dedicated, moved up, providing a dedicated manager and lifestyle director, are you suggesting that we are in a joint employer status? And if so, what should the association do differently from the prior to this webinar, understanding that the association really has no employees? So, Mike, you'd have to compare your practices to the tests in terms of a joint employer. So, um, we'd have to look at the test and actually go down. Is there control? Who handles the payment? Who handles the setting of the salaries? All of those, in my example I gave you, under a general test for a joint employer. Um, there are a number of tests that you would have to go through and um, and figure out factually what applies. Here's an example. I'm involved in a claim right now where the association is managed by a management company. Um, The management company is a part owner, what we'll say, of a concierge and security service. And the a guardhouse attendant is suing the employer, the security concierge company, but is also suing the association and the management company, right? Now that person is going to have a lot to prove. They're going to have to prove that there was control, that there was certain payment terms, all those factors, Mike, that we talked about earlier. But if she can prove that, um, she's going to have a successful case. If she can't prove it, she's going to have an unsuccessful case. Where's the rub? In the meantime, if she pleads things properly, just on the pleadings, the association is going to have to go through discovery, right? So if she were to plead, the association controlled how I did my job. She may not be able to prove that, but it's probably going to survive a motion to dismiss. And you're going to have to probably pay attorney through the association insurance company, obviously, um, to defend it. So do things like discovery. We had nothing to do with her timesheets and time card. Nobody in the association told her what to do. Nobody in the association told her how to do her job. Nobody in the association reprimanded her. Nobody in the association evaluated her. Nobody in the association disciplined her. We had nothing to do with it. The vendor did. You see what I'm saying? So it's going to be really fact sensitive. Regardless, it's going to involve attorney fees if it's properly pled. And as you know, plaintiffs' attorneys, they want as many people at the party as possible because they want to settle the case and they want to get a chunk of money from the association. They want to get a chunk of money from the management company. They want to get a chunk of money from the concierge service. So it's all fact-based, Mike. And we'd have to see what the business practices are going on there.
Uh,
Uh,
do you want to take the next one? Or you want to take it?
yeah, no, go ahead, Mike. We can read it at least.
So it says an HOA board member started a member chat group on WhatsApp. And for those of you who don't know, that's like basically a text type chain. This is a separate from any formal HOA communication, is not part of the HOA or management company. Does this present any particular vulnerabilities for the HOA? So I'll give a couple comments on this before I turn over to Fran. So this comes up fairly often where you have a board member posting things on social media, or like this, creating a group that they're involved with. And the problem is that there's the individual outside of being a board member, and then there's the individual who's the board member, and there are sometimes wearing the hat as a fiduciary on behalf of the association. So as you can imagine, that can create some issues for not only that individual, but for the board. So where you have like, let's say somebody reaches out to this board member on WhatsApp and says, hey, listen, there's this tree in the backyard. Do you mind if I just take it down? And if the board member says, I don't know, it doesn't seem like it would be a problem, and that board member goes ahead and does it, that's a possible issue, right? So the problem becomes the board member has what we call perceived authority. You're acting with authority, and we all thought you're the board member guy or woman, and you told us we could probably do it, so we did it. And when things like that happen, it actually binds the association to the actions made by that one individual board member, even though the board did not approve this. So it comes up fairly often where you have these issues. And if you ask me, it's a challenging situation because I know people have personal lives outside of serving on the board, but posting on social media and creating text chains through WhatsApp or whatever else does become problematic for board members when you're dealing with residents in your community. So I don't know, just keep that in mind. I don't know if you have any other thoughts, Fran.
Yeah, I'll add to that. So there is about a year and a half ago now. So as you know, and I've spoken about this before, um, associations, let's say this, non-domestic relation protective orders can now be issued. So we are on, so before a year ago, the only way you could get a protective order or restraining order would be in a domestic violence type case. The ex-boyfriend's trying to beat up the wife, he's stalking her, he's parked outside, all that stuff. Because the courts were under the statutes, were not really given the power to issue protective orders with respect to strangers, if you will. That was amended, and we're now starting to get that. So, but the criteria for it are stalking. So stalking, we're involved in a case right now where a gentleman waits for the property manager in the parking lot before she gets into work and just watches her, right? Is that a problem? I don't know, but it sure sounds like a problem to me. So we're in the process of dealing with a protective order application with that type of situation. But then there's also prohibited cyber harassment. And there can be cyber harassment. It's just, it has to be defined under the statute. And I don't have the statute in front of me. I could do another cyber harassment seminar, but um, people get really confused on cyber harassment as well as the topics that Mike just mentioned. Members, including board members, don't check their free speech rights at the door, right? So they can say things. Oftentimes, what they forget is that certain things are not just speech, right? They may be speech, but they may come with consequences like libel and slander. So, for example, you may be able to post on a website. I don't like people doing this, but I don't think the manager works hard enough. We should fire him. Okay, that's an opinion, right? Where things get dicey is somebody posts similarly, I don't like the manager. He is stealing. And the board goes, golly, our manager's stealing, and fires him. There's a really good chance that that person will be liable, right? Because they actually wrote and published something, if it's untrue, that caused that man to be damaged and lose his job because somebody reasonably believed it, right? So there's a whole area of law in that: libel and slander, number one, and also cyber harassment. Where do you have cyber harassment? I have pictures of you with your clothes off. And if you don't give me some money, or if you don't do what I want, I'm going to post naked pictures of you. Or I'm going to get naked pictures of you and I'm just going to post them anyway, just to make your life miserable. Right. You know, that can be stopped under the current protective order statute. That kind of nonsense can stop. And it's actually a little broader than that. So if you have people who are doing what you think might be cyber harassment, talk to your attorney about that, because it's pretty specific in the statute and you need to know what's going on. Another source of confusion with board members on other board members putting up bulletin boards online is many board members believe that anything discussed in executive session is confidential. That's not true, right? We've talked about that a lot of times. Just because it's discussed in executive session doesn't mean it's confidential. If we're in executive session and we're just talking about things like, I think we should have blue shutters, and somebody says, I think we should have brown shutters, that's not confidential. Generally speaking, it's not confidential. The confidential topics are generally hiring, firing, personnel, contract negotiations, um, inherently private, things like handicap accommodation requests, things like that. But general discussions regarding general topics um, are not confidential. You know, the other topics that are confidential are attorney-client privilege communications and litigation strategy discussions. But beyond those 4, 5, 6 things, um, there's not a lot that's confidential. So a lot of people will call us and they'll say, we want to do a board member removal solicitation because Bob talked about blue shutters and that was an executive session. No, no, we're not going to remove Bob from the board because he talked about blue shutters. It may be a very different story if that was part of a bid and it really had a substantive impact on the bid process or the bidding itself for the siding replacement job, but that's a different story. Let's see, what do we got?
Yeah, next question for William. It says, I know it's off today's topic, but some trustees at open board meetings can be very hostile towards certain residents, and at times the trustees gang up on the resident and can be insulting and demeaning. Any thoughts beside moving or using the courts? And I'll make a comment, and then Fran, you may want to too. So many of our communities pass a board member conduct resolution, which actually sets forth the parameters and the process for board members that are acting inappropriate, either towards residents or to other board members. And more often than not, the issue comes up where it's the aggressive residents that go to the meetings and harass the board. And in those cases, those communities, we do suggest passing a member conduct resolution, which again sets parameters and penalties for noncompliance. So that at least gives you some framework to work with, and you can go from there.
Right. So the other thing that, and I don't know if this would be the board president doing this or all of the trustees or just one of the trustees, but if there were, we'll say, non-hostile board members, the non-hostile board member can say, um, I think you're speaking inappropriately. I think Mary Jane should be permitted to ask her questions from the floor. And why are you shutting her down? She should not be shut down. You can ask that the record reflect that. And without, again, getting inciting too much, at some point, if board members are harassing people themselves, it may become a basis for removal solicitation from the board, either by the board itself, and I've had this happen, or by the membership itself. So the membership um, can demand that a board uh, go forward with a removal vote itself as a membership, not just the board. So sometimes that stuff can be the basis of removal. That's really annoying and really upsetting to the association. So the other thing that you can do, I haven't done this recently, but I've done it a lot in the past, is I've come in and done board member training seminars for like, an hour and talked about issues like that. It doesn't, in my experience, it doesn't serve anyone for the person in authority to be hostile. You are the person in authority. Why are you being hostile? Right? There's no point to it. You have the power, right? You can vote. The person from the floor, and oftentimes they bait people. I see this happen all the time. The person from the floor is baiting the board member, and the board member bites on it, right? No, don't bite on the baiting, right? Just conduct business and move on with your lives. Wouldn't the WhatsApp chat become discoverable evidence if there is a lawsuit? So yes, I would say probably. That's Anna's question. If there was a WhatsApp chat, would it become discoverable? Yes, it would be. Carlos, how is the employee versus contractor determination impact when a management company employee supervises and directs a contractor on a daily basis? Again, Carlos, we would have to apply the tests that I talked about earlier today um, to the actual facts and circumstances. So the fact that a management company employee supervises and directs the work of a contractor, you'd have to say, okay, well, there's a control aspect there, and then you'd have to go through the other um, elements of the test and find out, is there enough to make the contractor also an employee of the management company and or the association itself, right? So we would have to look at the specific facts, go through the test, and the contractor may very well wind up being an employee rather than a contractor. But again, very fact specific. It is extremely disturbing to homeowners to hear board members speak negatively about their fellow board members. I agree with association legal holding a board orientation. So yeah, I'm fine. I like board orientation. The more education we can get out there to both board members and the membership generally, I think it's great. As all of you know, it is very, very difficult and not very well paying to be a board member, right? So you catch all the flack, you catch all the nonsense, you want to do the right thing for your community. Oftentimes in your head, you're going, why am I doing this? I'm doing such a great job, and all I get is, right? Um, but thank God all of you do it. Thank God. We appreciate we you know what we should probably have? We should probably have one of these days, I'd have to think about it more, a first Friday with Fran, board member appreciation night somewhere. Because I know all of you board members really, and this goes for managers too, much of the time, not very much appreciated, right? The membership, even though they know full well that you're volunteers, you're not being paid for it, and you're spending your time and working hard and laying awake at night worrying about whether or not the roofing project's going to be able to be paid for. Um, you're not getting anything about it except for abuse. So I'd have to think about that. I don't know how. I'd have to think about how I can do that ethically, right? Because I can't just have giant parties. But I will think about that because board members should be appreciated. And as Colleen mentioned, I'm totally in favor of board members being educated. Al D'Amato. I second the motion for appreciation night. All right, Al. I know you're up for a party, so I will think more about that. Thanks for, thanks for, thanks for attending. And so it's Vanessa's thirding the motion. Mike Polito. This is probably the most popular thing I've said I've said in 5 years. Let's have a party. So yes, if I can figure out how to do a first Friday with Fran party, um, I will think about that. I will look into that, see if my office manager can come up with a budget for that, and if I can do it ethically, we'll have to do that. I like the idea. So it sounds like it's very popular with the attendees as well. Um, Most outrageous resident story day. I like that. Yeah, most outrageous first Friday with Fran, outrageous resident story day. So that would be good too. You know, I don't know. We could get a book out of this. I don't know. So, but I'm going to think about an event. So we'll see. I think that's it for today, though. But it's as usual, great to see everybody. I'm really glad you're here, and get out there in the sunshine before it clouds over and gets rainy. So we'll see you soon. Keep in mind, June's first Friday with Fran is what time? Noon, noon. So it's good seeing everybody. So we'll see you at noon. Great.
Take care,
Have a
everyone.
great weekend, everybody. See you soon.